and to this evening's public talk. And this evening, I'm delighted to have three enormously kind of heroic women, I suppose, of mine, to talk about a subject that I care about a huge amount, which is the extent to which, having introduced legislation against discrimination, in this case sex discrimination, that did or didn't have an effect in changing the world, which is why we now live in an entirely equal paradise where women have the same rights as men in every respect. But it did slightly shock me to realise that it was the 50th anniversary of the introduction of the Equal Pay Act and the Sex Discrimination Act, and there really had been very little academic or just social discussion about this, even in the university, and I thought it was something we needed to do a little bit about. I hope we'll do a little bit more about it maybe early next year. So to discuss this idea with me, I have three people. Here I have Dr. Lyndsey Jenkins. Lyndsey is a history fellow at Mansfield, and her specialist area is women and women's social movements, and particularly trade unions in the late 20th century. And she's going to talk a little bit about the history of the introduction of the Sex Discrimination Act. Then we have Tess Gill. She, of the famous Gill and Vino case, but Tess has had many roles in promoting equality for women through law as a trade union official, litigating in her own name, litigating for other people. And she's going to talk a little bit about that case and some other cases she's been involved in. And then we have Professor Sandra Fredman. Sandy is the doyenne, really, of equality law, a book about women and the law. I mean, she's written loads of books about equality and human rights, and everybody knows how great she is at this stuff. But her book about women and the law was the first book that I read in the 90s that gave me the idea that there could be a feminist approach to law, and it was worth sticking at. And Sandy also has been a solicitor for a trade union firm, and is an honorary KC and a barrister at Old Square Chambers, as well as her main life as a very distinguished academic. And she's going to reflect as well on the way legal change and social change in this field have happened. Lyndsey's got pictures, so Lyndsey's going to start off from the lectern, and then we'll do this conversationally, and we'll have time, I hope, for some questions with you as well. So thank you all very much for coming.
Thank you.
And Lyndsey.
Yeah. Sorry, it does feel a bit too lectury if I stand at the lectern, but I brought some pictures from an archive I've been working with. So thanks very much, Helen, for arranging this and for inviting me to be part of this wonderful panel. In my bit of the talk, I'm going to reflect on how the Act came to be, and what this suggests about that women thought about the role of law in achieving their objectives in terms of equality. I'm going to highlight its origins in anti-race discrimination and the reasons for its widespread support among both established women's organisations and the emerging women's liberation movement. And what I'm going to say comes out of a project I've been doing on a woman called Joyce Butler. I've put some merch on your chairs about that to publicise an exhibition that's going on all year. So Joyce Butler was the backbench MP for Wood Green between 1955 and 1979, and she played a central role in instigating what becomes the Sex Discrimination Act. So it's a story that starts unexpectedly with the Queen. In 1966, the Queen used her annual Christmas broadcast to speak directly to women, reflecting on the 100 years that had passed since the first suffrage petition was presented to Parliament. But where the Queen used her broadcast to talk about the progress that had been achieved for women, Joyce Butler instead expressed her frustration at how little they had actually achieved in that time. And at this time, she was looking ahead to 1968, which would have been the 50th anniversary of women's enfranchisement. And she saw this as a kind of unique opportunity to address what women were understanding as unfinished business, particularly on equal pay. And then at the sort of opposite end of the social scale, one day Butler was struck reading the newspaper by the complaint of a woman bus conductor who wanted to become a bus inspector, but was not eligible to do so because she didn't have enough experience driving buses. Now, the reason she didn't have any experience in driving buses was because women were not allowed to drive buses. They weren't hired to drive buses, and the trade union wouldn't support her case either. And later on, when Butler was reflecting on her role in this case, she wrote, "Like the light on the road to Damascus, I realised that this job and training discrimination was the key to women's failure to advance. We already had legislation against race discrimination. What was needed was a similar law for women. So earlier in 1968, Joyce Butler wrote to the Prime Minister, Harold Wilson, to propose the idea. But he was very reluctant to act on this. He said the government was already working to, quote, widen the opportunities available to women and, quote, prepare the ground for the implementation as soon as economic circumstances permit of the principle of equal pay. Now, the problem with as soon as economic circumstances permit is that that never happens, the magical day when we have enough money to pay women, and that's in fact code for never. He also claimed that the situation could undoubtedly be improved to a large extent by women themselves. So if only more women would take more responsibility, if they would get better training, and if they would only join trade unions, all this would be resolved without the need for legislation. But of course, Butler saw a more fundamental and structural problem here, which could not simply be addressed by individual action. And the solution that she came up with was a board which would tackle discrimination against women, and she very much had the Race Relations Board, which had been established by the recent Race Relations Acts in mind. And she saw it as having particular responsibility for addressing equal pay claims, because she saw this as the most significant ongoing manifestation of discrimination against women. Now, once this initiative was reported in the press, women began to write to her almost immediately, offering their support and explaining why they too felt this approach was necessary. So like Butler, many of them first and foremost saw this as a way of making equal pay realistic and achievable. But sex discrimination was also a cross-class issue. It drew support from factory workers and shop assistants and those working in the post office and public transport. So there are lots of letters like this in Joyce Butler's archive, kind of explaining the realities of this kind of work. But sex discrimination also attracted the support of professional women who found themselves unable to progress in professions that they had worked hard to enter. And it united women across age, from graduates fed up with being told that it was not worth hiring them because they would only get themselves married and then pregnant and give up work, to older women who had been affected by marriage bars early in their career. And as you can see here, material poverty is a consistent theme in the letters that women are writing to Joyce Butler. They hope that sex discrimination legislation would not only help deliver equal pay, but also address wider economic and social hardship, such as the problem of poor pension provision or the challenges faced by single mothers. However, it is also notable that at the time, some of those writing in also expressed frustration that sex discrimination did not seem to be taken as seriously as race discrimination. And there was a certain amount in some of the letters of frustration that migrant workers were somehow jumping the queue, and others were more explicitly racist. So as well as remembering that these debates about sex equality are taking place in the backdrop of debates on equal pay, they're also taking place in a kind of febrile situation around the rivers of blood speech. And of course, there's no recognition in these letters that the rights and needs of women of colour, the migrant worker was automatically assumed by white authors to be male, and unfortunately there aren't any letters from black or Asian women themselves. Now, the vast majority of correspondents to Joyce Butler were very supportive and determined to do whatever they could to support the bill. And at a national level too, women's organisations like the National Council of Women, the Women's International League for Peace and Freedom, the Open Door Council, the Married Women's Association, and the 6 Point Group all got behind the bill. And in fact, what happens at this moment, there's a combination of the suffrage anniversary, International Human Rights Year, and the belief that equal pay might finally be in sight. And it prompted something of a renaissance among the established women's organisations. And this was also an initiative which won cross-party support. Both Conservative and Labour women saw this as a way of removing barriers to further progress towards equality. And I think the first time that Joyce Butler introduces it is actually the first bill that's introduced with support only from women, and it's from all of women across the political parties. So because it was a private member's bill, it had no meaningful chance of becoming law, but she continued to introduce it for 4 consecutive years. And during that time, what we see is the development of a huge campaign, not just by women in political parties or in established women's organisations, but also by women who are part of the emerging women's liberation movement. And her archives testify to interest and support, so women are writing into her from Bristol, from Hull, St Albans and Fife. And for women who are part of the women's liberation movement, sex discrimination is important on multiple levels. It's a symbolic assertion of equality. It's a tool to utilise in service of other ends like equal pay, but also to achieve social and cultural change, for example, within education. So women's liberation movements activists are instrumental in creating a mass petition, hundreds of thousands of signatures, in favour of the legislation, and a big demonstration in London in 1973. And a new pressure group, Women in Media, was especially important in securing widespread positive coverage of this movement and helping to ensure that this was a demand which was increasingly taken seriously. It was also taken up and pursued by groups such as the National Council for Civil Liberties, who also later became central to the story of implementing the bill. And Butler continued to further her agenda in a variety of ways. For example, she undertook an investigation into discrimination in the civil service, and just to kind of connect this up to what Tess is going to talk about, she was also writing to a lot of employers and organisations about their policies, and here she's writing to Vinos. We're going to hear a lot more about this in a minute. So early in 1972, Joyce Butler hands on the bill to a colleague who finally had a meaningful opportunity to pass private members' legislation, and at the same time it's introduced in the House of Lords. But alongside this expanding feminist campaign, the other big shift in the early 1970s is Britain's membership of the EEC, which required signing up to stronger commitments on equal pay. So both the major political parties are now sort of stirred into action. The Conservatives in government put out their series of proposals on equal opportunities for men and women, and then when re-elected, the incoming Labour government publishes Equality for Women, which commits to anti-sex discrimination legislation and an Equal Opportunities Commission to enforce it. So this is the bill that's finally passed in 1975, alongside the Equal Pay Act coming into force after 5 years, and stronger protections for workers, notably when it comes to women in relation to maternity rights. So on the one hand, this is something of a feminist success story and an indication that the campaigning activism and the coalition building could pay off. But on the other hand, sort of cracks were already beginning to appear, and I'm sure we'll talk more about the limits of the legislation in our conversation. But women who had initially been thinking about sex discrimination as expansive and ambitious when it's put forward by an individual now have much higher expectations, and that's again kind of part of what the liberation movement was achieving. It was really changing women's minds about what they could expect. And they came to see the reality of these proposals as limited and conservative. Partly because it leaves so much untouched. It doesn't do anything about the tax system, the benefit system, the social security system. And so when most campaigners do celebrate when the act is finally passed, they also recognise that enforcement is really going to be the thing that makes the difference. So they worked really hard to inform individuals about their rights and to persuade trade unions to take up the cause. So the Sex Discrimination Act that finally passes is seen as a kind of starting place rather than a finished product. So I'll just offer a couple of concluding remarks before we think about how this law became a reality. First, I just want to underline the broad nature of the coalition which supported this cause. Like equal pay, sex discrimination was something which united women across class and across generation, and very much gained traction with ordinary women as well as feminist activists. And second, this effort tells us something important about the nature of women's campaigning in the 1970s. So perhaps you might associate the 70s with grassroots activism, with consciousness raising, campaigns for abortion rights, and against domestic violence, and the belief that the personal is political. And of course that's all very true, but conventional politics also remained important. This legislation had the potential to strengthen women's position in the workplace and therefore their capacity for economic independence and autonomy, which were the preconditions of women's liberation. And women's own professional skills in politics and in media, as well as in the law, were critical to achieving success here, and they would continue to be so during the implementation. And then finally, I think it's worth beginning this conversation with an explicit recognition that where there was political and social and economic and cultural change, that was because of women and the campaigns that they were undertaking. Legal rights are not bestowed from above by benevolent governance. They have to be won, and the fight was far from over. Thank you.
Thank you. So Tess, you started off working for a trade union and then later were a barrister, or a solicitor as well.
I started off as a solicitor.
Yeah.
Then I became National Legal Officer of the General Municipal and Boilermakers Union,
Yeah.
big union covering manual workers.
Mm-hmm.
And then I worked for a civil service union as a trade union official, and then I transferred to the bar.
Yes. And when I first came to the bar, Tess was a famous person at the bar, and I used to sort of smile shyly as she walked down the road. I think that's Tess Gill.
Rubbish.
It's true. And Tess Gill was famous for lots of things, partly for being a very good and nice and supportive female barrister, but also for this very famous case of Tess and Vino. And yes, when I first came to the bar, hanging out in those bars on Fleet Street was kind of what people did after work, and if you couldn't, it was a bit tough. So why don't you tell us the story of that case for a legal audience? And
Okay, so Albino's still there, and at that stage a famous wine bar, close to the Royal Courts of Justice, but in Fleet Street, and therefore also close to where all at that stage, nowadays no longer, all the journalists lived. And it was well known for a place where barristers, judges, and journalists would gather. Journalists would be keen to get gossip about the latest cases, and the barristers enjoyed drinking at the bar. It was also well known because it was well known that if you're a woman and you went in there and tried to join in the gossip, you wouldn't be served at the bar. You were told to take a seat, ladies. There were two tables at the front, or you could have to go in the smoking room at the back, wait for a waitress to come and take your order. So naturally, there was outrage at this, which was rumbling along for some time, and the Sex Discrimination Act came into force almost the first day. A journalist, Sheila Gray, stormed into Vino's and asked for a drink. She was refused. She brought a legal case and an injunction, and that was dismissed. A year later, it was a year anniversary, a group of women journalists thought we're going to take them on again, so they went in. Again, refused a drink, and they brought a case in the county court, and the county court refused their action, said that if there was less favourable treatment, it was de minimis, i.e. not important enough to constitute a legal wrong. 5 years later, I was on the NCCL, which has already been mentioned, National Council for Civil Liberty Women's Committee, and we have been active in promulgating what the Sex Discrimination Act was all about. It was now 5 years old, to particularly trade unionist women, and spreading the information. And we thought, we have to do something to mark 5 years of the Sex Discrimination Act. What should we do? So we thought we should take on Vino's. We've got to win this case. So we carefully looked at the reasons why the judge in the county court previously had turned it down, and the arguments that Vino's had used. So one of the arguments was, they said, well, when the bar's crowded, we don't like to have ladies crushed at the bar. So we're being kind to them to avoid that. Secondly, they said, ladies' handbags clutter the bar. So I think thirdly, they said, well, when we change the barrels, we might be able to see up the ladies' skirts, and that would be... So we decided, therefore, because the bar was frequented mainly by journalists and lawyers, we should have a journalist and a lawyer bringing the claim. So I was a plaintiff as a lawyer, and my friend Anna Coote, with whom I'd written a book, Practical Guide on the Law for Women, we'd written the book together, that she should be the journalist, I should be the lawyer. We would be the joint plaintiffs. And then we found two male witnesses, one was a lawyer, one was a trade unionist. We agreed to meet them at 11 o'clock, just when the Vino's was opening, so it was not crowded. We asked them, would one of them like to wear a kilt? But no, they declined that offer. So we told them to take in a briefcase each and put it on the bar, thus cluttering the bar. And we followed behind. They'd been served with a drink. We followed behind, and we went up and said, could we have a drink, please? And surprise, surprise, the barman said, do take a seat, ladies. And we said, well, we really want to talk to our friends at the bar. And because we'd recognised them and said, hello, you know, can we have a chat? And we were declined. And I think at that stage, Vino's did the barman kind of recognise something was going on here. Anyway, we refused to drink, so we left. And the men, of course, stayed and enjoyed their drink. So that was the basic facts for our claim. And we brought our claim in the county court. And we had a county court judge. And he understood, he set out why we were put at a disadvantage. We couldn't get a quick drink at the bar. Waitress service was slower. We couldn't join our male friends at the bar. If male friends won't join them, we have to separate. And that we said, although he didn't accept it, that being treated differently was embarrassing and degrading in this day and age. When we work on the same terms as men, we should be treated on the same terms when we have a drink. But he found that the provisions of the Act must be applied objectively in a common sense way and to the standard of a reasonable person, which we plainly weren't. And he said if there was less favourable treatment, it was so trivial that in all the circumstances it should be disregarded. So at that stage, the claim failed, so we had to take it further. So we took it to the Court of Appeal, we filed our notice, and the next issue was that we would need funding. Up to now, very kindly, solicitors had acted for us pro bono without charging, and as indeed Melville Williams had acted for us leading counsel. But at the stage of going to a Court of Appeal, there would be a threat of costs against us, so we had to get funding. So we applied for funding to the Equal Opportunity Commission. And initially they were very supportive. We spoke to the legal officer. But at that stage, the person who advised them on funding applications was Anthony Lester QC, a famous lawyer, the one who had drafted, so he would tell us, the Race Relations Act. And so he was asked to give an advice. And he gave a lengthy opinion, and he concluded that the appeal was unlikely to succeed. Even if it did succeed, it was unlikely to decide any important question of principle, and that the Commission may well be strongly criticised for having been given assistance for an appeal by the court or by others. He characterised the case as being essentially artificial and trivial, and therefore like to make bad law or no law. So that opinion landed on the 20th of October, and we were told by the Commission that that was a Friday, we had to provide an alternative opinion by the Monday, or it was most unlikely that it would be funded, in which case the whole case would collapse. Our QC, Melville Williams, had gone to the country, and we were told he wouldn't be able to draft an opinion over the weekend. So I thought, nothing for it, I'd have to do it myself. So I wrote a contrary opinion, and I look back, 82, I couldn't have had access to email, because I actually dictated that opinion on the Monday morning to the Equal Opportunities Commission's legal officer, to his secretary. It went before the committee, and at that stage we had a champion. It was Elspeth Howe, who was Geoffrey Howe's wife, and she had been, I think she was on the funding committee, and she had been the deputy chair of the Equal Opportunity Commission. She stood up for us, and as a result, we got the funding. And the case went before the Court of Appeal on the 8th of November. So big day, we're there, we've got the three judges, Lord Justice Evely, Lord Justice Griffiths, Sir Roger Ormrod. First thing that happens is that they say, three of our brethren, they said all of the brethren, we didn't say habitued, but we regularly go to Vino, as I said, to varying degrees, and it may be that you wish to recuse us, i.e. say that we shouldn't hear this case because of our knowledge of Vino's, but we didn't take any objection to them, quite wisely, I think. And they went on to come out with a splendid judgment, universally in our favour, and they got the essence of the case. Evely said, what is the comparison in this case? A woman is denied certain things a man can have. As a matter of fact, in this case, what are they? She was denied the opportunity to drink where others drink, to mix with other people who are drinking at El Vino's. She was denied a choice of companions, and so on. And Lord Justice Griffiths said, I agree. El Vino's is no ordinary wine bar. It's become a unique institution in Fleet Street. Every day it's thronged with journalists, solicitors, barristers, exchanging the gossip of the day. No doubt it's the source of many false rumours, which have dashed the hope of many an aspirant to a High Court appointment. Now, if a man wishes to take a drink in El Vino's, he can drink if he wishes by joining the throng, which crowds round the bar, and then he can join his friends and pick up, no doubt, many interesting pieces of gossip, particularly if he's a journalist, and so on. But if a woman wishes to go to El Vino's, she's not allowed to join the throng before the bar. So they had no doubt that this was less favourable treatment, and they found it in his favour. For the lawyers amongst us, there's a slight disadvantage, because it'd be nice if they said that this notion of de minimis had no role whatsoever in equality law. And although Evely said he found it difficult to see how it should have a role, because, after all, we were being denied exactly what the Act, Section 29, said we shouldn't be denied, which was equal treatment, they actually found on the facts that we were plainly treated less favourably. So de minimis could kind of creep in. But other than that, we were very satisfied with the judgment. And, of course, we went down to El Vino's to celebrate, at which case... However, we were then denied a drink. Management claimed that their refusal came under a common law provision which stated that a landlord has the right not to serve anyone he pleases if he judges them to be drunken, violent, quarrelsome, or disorderly. So, in the end, our lawyers threatened to go back to the Court of Appeal, and they very bad-temperedly said that they would serve us, at which stage we said, well, we don't want to drink from you anyway. So And the slight postscript to all this is 35 years after winning the case, we were welcomed back, new management at that stage, as guests of honours, and they said that they would give any takings from the evening to Fawcett Society, which is a society in support of equality. So Anna and I went back, and we had a jolly good evening. Champagne and God knows what. And now I believe, cheeky, they have a plaque on the door of El Vino's celebrating the case. And you might just know the background of El Vino's. It was founded by a wine merchant and former Lord Mayor of London as Bower and Cohen in 1879, and subsequently passed to their nephews, Christopher Mitchell and his brother, Sir David Mitchell, who was a cabinet minister in Margaret Thatcher's government, and father of Andrew Mitchell, the former Conservative chief whip. So that's that. So there we are.
Oh, wow. Thank you. And Tess, one of the things, I mean, it's really interesting to hear the human story of that case. I mean, people who are lawyers or law students here will know how dry it is to read a law report. This happened, that happened, these are the dates, these are the principles that they sort of dry it out for you. And there's this real human story there. And I think that part of the importance of this case was in kind of grabbing that human attention. And we were talking just before we came in about how dry the Equality Act, which is the current form of equality legislation, is, and how it sort of, it's hard to see the human being in the middle of the case because its principles are if X does Y to Z, then it's sort of A and B, and it takes out all that sort of humanity and the social background of it. But I mean, do you think, well, was the reason for you to take this case partly that sense of we need to have a human story that draws political attention to this? Was it?
Well, I say we thought it was outrageous that this, because the case was well known, and it was outrageous that El Vino's were getting away with it.
Yes.
And we wanted something which said the Sex Discrimination Act isn't just there on paper, it actually can work.
Yes.
And now the wider issue was that this was not an isolated case about a wine bar. And in fact, Sandy was telling me about an early instance of hers when she couldn't go to drink with her colleagues because it was a club which didn't allow women in, which of course has lasted for over many years.
Yeah.
And thinking about trade union life, working men's clubs would commonly not serve women at the bar. I was, when I was a trade unionist, went up to our northern region. There was only one woman official among all the male officials. They used to go and drink and talk in the working men's club. And women could only only be allowed where there was a carpet. And there was no carpet round the bar. So they weren't allowed to be served at the bar. So it was a wider issue than albinos.
And when I came to the bar, which was in the 1990s, I represented a trade union, a train drivers' union, that there was one female train driver in a region, and they didn't want her in the working men's club. And they said that was, they had a rule, it wasn't because she was a woman, but they had a rule that only one member of a married couple could be a member of that club, and her husband already was, so she couldn't be. Yeah. And they knew she was the only woman, so effectively they were doing the same thing. One of the other, I mean, you also did some cases that look at the kind of structural elements of equal pay and indirect discrimination, which is when a rule doesn't seem to be discriminatory on its face, but does have a discriminatory effect. For example, you have to be over 5'8" to be a police officer. That would be an indirectly discriminatory rule. So I just wondered if you might want to talk about Hayward and Campbell Laird, which is another very important case.
Yes. So when I was at the GMB, General Municipal and Boilermakers, we were looking for strategic cases, again, to progress the implementation of the Act. And the Equal Pay Act was in its very early stages. And to start with, the only comparison you could make was if you were doing the same work as a man, but you weren't paid equally. Whereas for many women, they were doing different work, but they said was of equal value, but they weren't being paid equally. And later on, there were equal value regulations, which allowed claims where you were doing work of equal value. So we wanted to progress this concept of equal value. So we chose a case of Julie Hayward, who was a cook in Campbell Laird's shipbuilders, and she worked in the canteen, which was a big industrial canteen. She was a big, strong woman, and she was paid less than, she'd done her apprenticeship, and she was paid less than the men who'd done their apprenticeships, and so we chose a carpenter, a plumber, an electrician. So 3 male comparators, all who had finished their apprenticeships and were craftsmen, and the assumption, of course, was that she was a cook in a kitchen, and presumably people kind of imagined like a domestic kitchen, but far from it. I mean, she had the same, first of all, she had the same skill as the men, and she also had the same demands on her in terms of physical work and labour. So luckily, she was a strong supporter of the local football team. She was popular with the men, and they were all happy to give evidence on her behalf. But we then had to construct an equal value structure. So we went to the Equal Opportunity Commission and worked with their main legal officer and brought in an expert. And we had to represent us David Panic, now a very famous leading QC, then a young, unknown barrister, and argued the case before the tribunal and succeeded. So it was a kind of predecessor case before the equal value regulations came into force.
Yeah. Fantastic. Sandy, I mean, do you want to talk a little bit about the... So Sandy does a lot of policy work in equality law still, as well as teaching and researching on it. I mean, what do you think about this way that change did or didn't happen through equal pay and equal and sex discrimination legislation?
Yeah, well, thank you so much. I just want to say how thrilled I am to be here and to hear about the oral history and to be with Tess again and hear about the stories. And you know, I mean, you tell the story, but it really took a lot of courage and a lot of determination. And what I want to pick up on is how important the role of women was in making this act happen and in taking it forward. Women like you and like the ordinary trade unionists who went on strike and who continue to try to make these laws real, so that laws really have to be an interaction between the people to whom it matters and the legal structure. So I wanted to start with those two men that you mentioned, Anthony Lester, who was this famous barrister, and also David Panic, actually. And when Helen and I were discussing this, I recalled that David Panic, who is, as we know now, a really, really important barrister and who's an excellent lawyer, but he wrote one of the first books on discrimination law. And I recalled, Helen checked it, that in the first edition, the acknowledgement is to Anthony Lester, whom he calls the father and mother of discrimination law. And so what I want to do is counter the fact that here were these men who were, yeah, of course, they did a huge amount, but how could they be both the father and the mother and write us out of the picture altogether? Whereas the fact, of course, of women is that their roles as both mothers and workers need to be valued and acknowledged. So that's the starting point. And just to go back to the history then of the Equal Pay Act, just to fill in some of the bits, that of course one of the big, so the Equal Pay Act only came into effect at the same time as the Sex Discrimination Act, although it was it was passed in 1970. Employers were given 5 years, 5 whole years to adjust their pay to bring it into effect. So we can count this as part of the 50th anniversary of the Sex Discrimination Act too. But there were a few strikes. In that process that you talked about, there were also the really important work that was done by striking women, and particularly the women who went on strike at the Dagenham Ford plant. And the crucial thing, coming back to the point about equal value, is that these were sewing machinists, and they were making the seat covers for the cars. And they were paid, like all women at that time, were lumped into the bottom grade of unskilled workers. And so they were paid considerably less than the men the men workers, the skilled workers at Ford. But they were very skilled. You know, they had to do this really quite difficult sewing work, but because this is women's work, it was not valued. So they went on strike, and I think probably that, well, as far as the history goes, that was always accredited as the precipitating factor which finally got Barbara Castle to take up the case, to take up the claim that we needed an Equal Pay Act, and started the process and got the Equal Pay Act passed 2 years later in 1970. And I would really commend, if anyone's interested in this, that our common colleague Jo Morris, who was in the TNG, she has done these wonderful oral histories of the women who were involved in these cases, just like the story that Tess has told. So the Equal Pay Act was nevertheless quite limited, but it was a big landmark act, but it was very limited, because as Tess said, all it did was to say that if you were doing the same work as men, you should be paid the same. And because there were so many women who were paid like the Dagenham Ford machinists at the bottom layer, and none of their skills were recognized, actually, when the Equal Pay Act did come into effect, there was quite a big jump for many women, and the pay gap narrowed from somewhere in the early 60s to around about 70% of men. But after that, it stuck there. So the movement that the women were taking, and there was this wonderful case of Hayward, which Tess has talked about, which was trying to get beyond the notion of like work. And that's where the fact that the UK then entered the European Union makes a big difference, because the EU is often described as being a top-down imposition of laws on the UK, but actually what was happening was, I think, very much a joint endeavour by women's groups in the UK and women's groups in Europe who were advancing the cause of equality for women. And there was a professor in Belgium called Dr. Elaine Vogelpolsky, who was very foresighted, and she decided, just like Tess, to bring some test litigation before the European Court of Justice on the issue of equal pay. Now, the Treaty of Rome, which was the original treaty of the European Economic Community, had Article 119, which did require equal pay for men and women doing equal work. But no one had paid it any attention, and this is another lesson about how you actually need activists, you need social movements and women, or whoever is the stakeholders are, to be motivating. And Elaine Vogel-Polsky brought the famous case, which some of you might know about, called Dufresne and Sabina, which was an air hostess who was working for Sabina Airlines. And what she argued on behalf of Dufresne was that even though Belgium had no legislation at all on equal pay, the very fact that they were members of the European Union meant that European Union law was, could be applied in a court in Belgium. So those of you who've done EU law will perhaps know this case has been talking about vertical and horizontal direct effect, which is a legal term, but basically what it was saying was that the European law, which was in the treaty, could be applied if the legislature hadn't done anything about it. And when they talk about horizontally, it means it could even be applied against private employers. And that's, of course, where a lot of this discrimination was happening. So the Dufresne and Sabina case was, again, a really important input by women to make sex discrimination law meaningful and matter. And that was about 1975, which was about the same time as the Sex Discrimination Act. And in the very next year, there were two EU, what we call directives, which are like legislative provisions, one of which was called the Equal Treatment Directive and one of which was called the Equal Pay Directive. And the Equal Pay Directive imported this notion that it wasn't enough to have equal pay for like work, but you should also have equal pay for work of equal value, which then brought to fruition the notion that women's work, like the sewing machinists, just because it was seen to be women's work, like the cook at Camelot, just because it was seen to be women's work, was paid much less. And instead of looking at what was actually being paid, you could take the job apart. You could look at the level of skill, the level of responsibility, whether it was heavy work. And once you've broken that down, you could actually see that the cook was doing work of equal value to the carpenter, that machinists were doing equal work to some of the workers, the other all-male workers. And there was some, after that, because EU law, and this is, again, a very constructive interaction between EU law and the UK law, but because EU law was binding, the UK was required to implement the Equal Pay Directive, and the European Commission brought proceedings against the UK. It was called Commission versus UK, which I'm sure you remember, which meant that this notion of equal value was then incorporated into the Equal Pay Act. But even that's not enough to have it there on the statute book. You needed test cases like the one that you talked about to make sure that these things actually happened. And there were those cases that you talked about, and then there were some other really important ones, like Enderby, who was a speech therapist, who brought a claim because speech therapists had been traditionally more lowly paid than others, like clinical psychologists. And that wasn't just because it was women's work, but because there were many more part-time work opportunities, and therefore it was thought to be the kind of work that women could fit in with their other obligations. And in all of these cases, it's important to say that generally speaking, the trade union was very supportive of them. And certainly Enderby talks about how her union funded the whole case. It was a long, long process. I think it was 10 or 15 years before she got to the end of the process. And you needed a huge amount of stamina. I don't know how long your case took, but it must have been quite a while once you got to the Court of Appeal and and back.
Well, it had to go, well, I'm thinking it has to go through so many layers,
That's
doesn't it?
right.
It starts with the Employment Tribunal, then it goes to the Employment Appeal Tribunal. From there it goes to the Court of Appeal. And unfortunately, sometimes it's then bounced back to the Employment Tribunal to make different findings of fact, and then it can go all the way up again before you get a final decision. So
it's
yes,
very
I mean,
slow. So
yeah,
you
it
need
can
to be
take a long
very
time.
tenacious.
Yeah.
You need to have people who are really prepared to stick it out.
Yeah.
And I'm sure you had clients like that. But the other thing which is important to notice is that actually some of the unions did this not through the courts, but through collective bargaining, which maybe is the best way of doing it, because they could then deal with a whole grade. It wasn't just one individual who had to bring her claim and find a man to compare herself with, but they could try and readjust the whole grade. So in local government, for example, there was a very big regrading structure. And one of the really important things was that they then could say that was what was then called home helps, which we would now call domiciliary care workers. But they were doing work of equal value with garbage collectors. And that their basic pay should be the same. Now, garbage collectors have traditionally been very highly unionized and had a lot of industrial strength, because if you go on strike, as the people in Birmingham know, if the garbage workers go on strike, then they have a lot of, they then particularly had a lot of power to increase their pay, whereas if a home help goes on strike, all that happens is a poor person, a poor, dependent, vulnerable person goes without help. So, and they were also in lots of little small workplaces, so it's difficult to take industrial action. So the collective bargaining side of equal value also needs to be factored in as to how the Equal Pay Act was made important. In the meanwhile, I think we should also look at some of the other advances that were made through the Sex Discrimination Act. And one of the really important ones was on part-time work. And this was, again, a really interesting and constructive interaction between the UK and groups in the UK and the EU and the development of the law in the EU, because it was very well known, it was absolutely standard that part-time workers would be paid less per hour, not as a whole, but per hour, than full-time workers, simply because they were working part-time. And they were, because women then and still now remain primarily responsible for childcare, women probably constituted about, and still do, about 90% of part-time workers. So the question was the fact that part-time workers were paid less than full-time workers a question of sex discrimination? Or was it discrimination against part-time workers? And for that, which from a sort of social perspective seems obvious maybe, that the fact that they were paid, that part-time workers were paid less, were because they were women workers, because they didn't have many choices about what work they could do, because they needed to take whatever work they could, because it was much more difficult to unionize. But as far as the law was concerned, what they were looking at was saying, well, you're not paying them less because they're women, but because they are part-timers. And Helen mentioned the concept of indirect discrimination, which is to say that if you treat people the same, but nevertheless it has a disproportionate impact on women, then that can also be discriminatory. This was a concept which actually originated in the US after the Civil Rights Act, when many employers tried to resist integrating their segregated workforces on grounds of race by bringing in things like selection tests, which were unnecessary because you didn't need to have a literacy or high school qualification, but they thought would keep out black workers who had not been allowed to be at school and had not gained the requisite qualifications. So the US Supreme Court developed this concept of what was called disparate impact. Anthony Lester, coming back to him, always told the story of how he physically brought back the concept of disparate impact from the US when they were drafting the Sex Discrimination and Race Relations Act. He and Roy Jenkins, he always, I'm sure he's told you that many times, but he did love to say that he physically created this transplantation of disparate impact and put it in statutory form in the Sex Discrimination Act. But we have to give him credit if that is what he did, because it is a really powerful concept. And it was not present in EU law at that time, because EU law had a very bland concept of equal treatment between men and women. But the part-time workers cases were the cases where, again, some test cases, some from the UK, Jenkins and Kingsgate, some from other countries, Bilker, Kaufhaus, where the litigants came to court and said, this is sex discrimination because although it looks like a neutral provision against part-time workers, actually disproportionately affects women, and therefore you should count this as not just discrimination against them, but unequal pay for the same work or work of equal value. And slowly over the years, the European Court carried on developing a concept of indirect discrimination simply through the part-time workers case law, while in the UK, those concepts had to come back and be put into practice through providing equality for part-time workers, until eventually we got the part-time workers directive, which was still not quite as good as that. And then the other things, we were talking before about pregnancy discrimination. Again, this is something which, on its face of it, the Sex Discrimination Act probably didn't necessarily cover, because you had to show less favorable treatment because you were a woman. And then there were all these tendentious cases where the court said, well, you can't get a pregnant man, so we can't count this as sex discrimination. But the European Court, in cases first brought from other countries and then also brought from the UK, said that discrimination on grounds of pregnancy was intrinsically discrimination on grounds of sex. And that had to be imported. And actually now, although there are still many, many, many pregnant women who get dismissed because they're pregnant, the doctrine of pregnancy discrimination, of pregnancy as a source of discrimination, is very strong, to the extent that when the Equality Act came in, it was included as a ground on its own. So I think what we're seeing is this fertile interaction of how the Sex Discrimination Act had some really important impact because of the way in which it can interact with social forces. But maybe I should also end with the caveat that it's not all like a rosy picture. The trade unions were largely supportive, but the problem with equal pay is that it landed up pitting the male workers against the female workers in many situations, partly because the equal pay didn't require women's pay to necessarily be raised to men's. It could allow men's pay to be slowly brought down or quickly brought down to the same as women. So that made men, quite understandably, the male trade unionists, quite hostile in some cases to women's claims. And the result was that the unions had to make a call as between their women members and the male members. So some of the unions, GMB at the time included, I think, although you can say otherwise, they made a call for their much more outspoken male members in some of the cases, and the TNG even as well, where they then said that although we've had this equal value, we have home helps and refuse collectors on the same basic pay, we're not going to take away the long history of giving garbage workers bonuses, and we will allow the bonuses to carry on, and we will protect those better paid workers in what was called red circles.
Red circle.
Red circles put on the pay grade, which women were not allowed to become part of. And also, because there was quite a long, those of you who followed the Birmingham dispute recently, the Birmingham so-called, when Birmingham went insolvent, they said that was because of equal value claims against them. But that was partly because they didn't really ever pay out the pay that they should have paid, partly because there's quite a long back pay period of 6 years, which means that the longer you resist the pay claim, the more your bill rises and the more they resist it. And at which case the unions came to a compromise, they called a compromise with the employers to say, that's okay, you don't have to pay the women the back pay they owed. And the sad story, you must remember, I think we all felt very sad at the time, was that the result was that the women brought a claim against their own union for sex discrimination. And we've talked about some cases, quite a lot of cases where the women won, but actually the large majority were lost in the way that you said. And one of the very few cases which was won in the equal pay field was against the union rather than against the employer. And that felt a pity. But in the end, there was a very outspoken solicitor called Stephen Cross who took the cases for the women and went to tribunals and won quite a lot of them against the union. Now, actually, and this is well in the GMB in particular has entirely changed, and there's a very active women's unit in the GMB. You probably know them. And they're working together with Stephen Cross. I don't know if you knew that. But, and they are now bringing a large number of equal pay claims on behalf of shop workers, Tesco's, Asda, Next, really massive equal pay cases, which you might want to keep an eye on. But I could talk more about that, but I won't. Yeah, but
I ought to leave some time for questions, so let's yeah, but it's absolutely fascinating. I've got lots of questions, but I'm not going to ask them because I want to leave some time for other people. And it is really interesting to see how that sort of ratchets up, and the links between the kind of normative effect of the law and the collective action and the using the law to try and get a remedy in individual cases. I'm sure there'll be some questions from the floor. I will take some for a few minutes, but I understand some of you may need to leave. But let's start with anyone who'd like to ask a first question. Yes, there's a hand just there. If you can just wait for a microphone, please, so people can hear. Thank you.
Hi. More of a comment than a question, really, but I was a pupil barrister in the early 1980s. I was the first pupil in that particular set of chambers, and I was told couldn't possibly take you on for a tenancy. No. We have to offer people a choice, you understand. So I was referred to another set of chambers. He said, no, we, head of chambers doesn't like women, terribly sorry. And the head of chambers said, sorry, the clerk just won't have women. So, and in the end, I joined the government legal service, who were absolutely fantastic. But even as late as the 1980s, there was a kind of feeling that equal pay or equal treatment somehow didn't apply unless you were formally employed. And of course, as a pupil barrister, you weren't. But anyway, the fight goes on, and it has to go on, doesn't it? Because women, the great golden age hasn't actually happened yet. But it's such a pleasure to hear everybody on the same side, basically, even though we come at it from different directions. So thank you very much.
I'm not the BBC. I'm allowed to have a circle of people who take a perspective on something. But yeah, there's just a hand. Sorry, can I just wait for the microphone to reach you? It's coming that way. Yeah. And you still need to project a bit. They're not entirely.
Jo Morris. Was working at the TUC, not TNG.
Sorry.
And the question is, what now would make the most difference to promoting equal pay for work, equal value? But before I pass it over, I'd just like to commend the TUC archive. You can find it on the TUC library website under Recording Women's History. And it has interviews with the NB claimants, Julie Hayward, the Ford sewing machinist, and incidentally the Asian workers who worked there, who actually we had no idea about until they came up to TNG head office for an award. And this whole Coachload came out, and their stories are fascinating. And there's also one which I really would recommend, which is the Hull Fish Workers. And that the T&G officer took 25 cases, 24 of them were successful. He didn't have any help, he did them on his own, they didn't go to appeal. Don't think any of them did. But the point that I think comes out of all of that history is the importance of activists and also and lawyers working together to identify and to promote and push things, and the importance of trade unions. Because all of those cases are trade union cases, and the fact that most of them had really strong support from male officers and male members. Not all of them, but Julie Hayward's one was very clear. And the Yorkshire Dinner ladies one as well. They are terrific. They're really lovely. They're heartwarming in a very depressing age.
And I was just going to say on the back of that it is important to kind of underline the importance, the factors that made these cases successful, because although we're talking about the cases that were successful, this was a tip of the iceberg. Most of them weren't. Most of them never even got to tribunal stage. So there were so many other stories of women who just who never got that far, and the union backing was really crucial in the cases that were successful.
And I suppose also the collectivist thing, because although you can bring a case as a brave individual in a workplace, I mean, you were bringing a case, and if a services case, they're quite unusual, but you're bringing a case in a workplace, although there is a law that says you can't be victimised for bringing a case, it's very hard to show that the reason they're all suddenly turning against you is not that you're the troublemaker who brought this case. So you do need that kind of solidarity if you're bringing that kind of thing. You want to say about that question about the what now? What's the best way to keep going with this stuff?
Well, the Equal Pay Act is really not fit for purpose, mostly because it doesn't give enough space for collective.
Also, it's hideously complicated. The procedure's hideously complicated. It takes far too long. It ought to all go to some arbitration tribunal. Yeah, deal with the facts quite simply, in my view. Yeah.
And maybe have a requirement, which is a thing we could be working on, of employers actually to institute, in the same way as that local government equal value, but to institute it without having to be prompted by one individual. Also, all these preliminary objections which employers keep taking, which is why it bounces back up and down to the Court of Appeal, that needs to be got rid of. But I think, and I'm sure you would agree that, I'd like to know what you think, rather, that we need to have a duty on employers to do this without having to have an adversarial complaint by individual women with all the costs and trauma and difficulties that takes, and time.
I think that positive obligations approach is important. Probably got time for one more comment or contribution if anyone wants to make one. Nope, I'm blind. Oh yes, there's a hand here. Okay, we'll take that one and then we'll draw it to a close. So.
Yes, hello. Firstly, thank you.
Sorry, the mics aren't very good. You have to project still.
Okay, right.
Yeah.
Firstly, thank you all very, very much for your insights and your stories this evening. You've been absolutely wonderful and very insightful. My question pertains...
Could you move the mic up a bit? Sorry.
Again?
Yeah, thank you.
Yes, that's great.
And my question in particular is in relation to the new visa rules that the government have recently implemented. So with this, for working in the UK, they've obviously moved the pay bands. And I can imagine this has quite a large impact in terms of sex discrimination and pay, particularly for women who are looking to come and work in this country. I wondered if you had any insights in relation to that area and essentially what that change might well bring.
I have a view on this.
I didn't catch that.
Yes. So the question, because the mics aren't very good, was about the pay bands that have been increased for visas to work in the UK, where to sponsor somebody you have to get a lot more, you have to earn a lot more money, and because women traditionally earn less than men, that's indirectly sex discriminatory. I agree. The problem, and it is one we could have discussed this, but one of the problems about the Sex Discrimination Act was it carved out a lot of areas of public policy, which included social security and immigration decisions, basically public decisions, or decisions taken in other legislation. And it's been really challenging those happened through the European Convention on Human Rights, and there were cases about people in the 80s about women sponsoring their husbands to come to the country on, and things like that. But there have been cases since the Human Rights Act's come into force. A number of claims have been brought through that, trying to say that the right, if you have a right, a civil right, and you can establish that, then the state can't discriminate unless it can justify it. But the courts, and particularly recently, have taken an incredibly hands-off view, partly because of the attacks on judges getting too political, and have tied themselves into a tiny little box about when they will take on a case of that kind. And they use this concept called the margin of appreciation, where they say that's not for us, and they won't generally get into a case, even if it's obviously discriminatory, unless it's what they call manifestly without reasonable foundation, which is almost impossible to prove. So it's really, I think you're really right, and it's just, in a way, that's one of the problems about trying to create social change through law, that there were some quite good cases on that, and then a slightly different textured Supreme Court has rode backwards, and actually I think or things like the two-child rule, which massively affects women more than men, because they're far more likely to be poor parents, single parents, poor parents of two or more children, and single parents who are mostly affected. And I think those things like that are going to have to come through political movement, because there are limits on the law as an instrument of social change. You could campaign to change the legislation, and then maybe you would be able to, but that's my view, that it's really hard.
Lost Brenda Hale.
Yes, well, no, honorary fellow of Mansfield College, Oxford, but no longer the president of the Supreme Court, unfortunately. So, thank you all for an amazingly interesting evening. Thank you all for your coming and engagement and interesting observations and questions. Next week, our public talk is the extraordinary writer Hisham Matar. He wrote a book called The Return, which won the Pulitzer Prize, and his lecture next week is called To Know and to Know Not, which is a talk that he first gave in Florence last year about being an Arab in the West today. It's an extraordinary talk, so do come along if you can. And then the week after that, given that you're people who are interested in social policy, Torsten Bell, who's the Labour MP for Swansea West and Minister for Work and Pensions, is coming, and he used to be the Chief Executive of the Resolution Foundation. So if you're interested, do come along to one of those. But for now, please join me in thanking Lyndsey Jenkins, Tess Gill, and Sandra Fredman for an amazing evening. Thank you.